Good morning. The committee will come to order. The Oversight and Government Reform Committee's mission is that we exist to secure two fundamental principles. First, Americans have the right to know that the money Washington takes from them is well spent. And second, Americans deserve an efficient, effective government that works for them. Our duty on the Oversight and Government Reform Committee is to protect these rights. Our solemn responsibility is to hold government accountable to taxpayers, because taxpayers have a right to know what they get from their government. We will work tirelessly in partnership with citizen watchdogs to deliver the facts to the American people and bring genuine reform to the Federal bureaucracy. This is the mission of the Government Reform Committee. I'll now recognize myself for an opening statement. President Obama on January 4th executed a political power play. He put us in uncharted territory. At the very least, it creates uncertain environment and significant risk by his own attorney's writings. Although, as I know too well, if you shop enough, you can always get an attorney to give you the opinion you want. You can go to enough attorneys, you'll get it. And if you hire a good attorney, they'll even tell you you can pardon a criminal that is still a fugitive from justice. We know that from history. We know that from recent history now, that you can get an opinion that is exactly the opposite of centuries of precedent, exactly the opposite of your predecessors, exactly the opposite of still Majority Leader Reid's own view of recess occurring or not occurring. Vice President Biden in 2005 said, "No president is entitled to the appointment of anyone he nominates. No president is entitled by the mere fact he has nominated someone." That's why they wrote the Constitution the way they did. It says, advise and consent. The Senate did not consent. The Senate chose specifically not to act, even bringing to a vote and failing to get cloture. Ultimately, we will decide nothing here today. We are here to evaluate the risk to the American people of a government that has appointees who may not be able to act on behalf of the American people with the rule of law. The courts will soon decide, and the sooner the better, whether or not these appointments are valid, and if so, whether or not a law limiting taxes to the American people is valid. Because there can be no doubt the two cannot be valid. You cannot be in recess and not in recess. You cannot choose, while in recess, to pass a law, and then choose to not be in recess for purposes of recess appointments. Ultimately, these and other issues will be decided, but the committee is here to understand the risk, to understand the likelihood, and at least to ensure that government begins facing the real problem of this uncertainty that may last only a few weeks or may last for the rest of this administration. On December 23rd, while in pro forma session, the Senate passed and President Obama signed the Temporary Payroll Tax Continuation Act of 2011. I am just as concerned that the IRS is not collecting those taxes when clearly they were in recess, according to the President. This creates another constitutional question. The Constitution did not consider partial recess or recess for this purpose and not that purpose. You're either in recess or you're not. More importantly, the Senate may not act to be in recess to the exclusion of the other body. We, in fact, act together. We either are together as required by the Constitution or we are not. There is no such thing as the House is in session and the Senate is not, because if we are in session and the Senate is not, no law can be passed. Our Founding Fathers anticipated us coming to Washington, or New York before that, for a period of time, and going home to our constituencies for a rather significant period of time. Many Americans, rightfully so, think that we were better off when we left town for a period of time and really got in touch with the people we represent. But that's not the issue here today. We are now a 365-day-a-year Congress. We are at call of the President and can be back in a matter of hours. And when we are, in fact, in pro forma session, that's the anticipation that if needed, we will be back with a full quorum in a short period of time. U.S. Senators were informed that, in fact, they could be called back. They were informed that they were not in recess, and they made that decision. Today we will hear from a prominent United States Senator, but more importantly, we'll hear from a constitutional scholar, the son of a constitutional scholar, about what he believes as a senator. Then we will go on to hear from other witnesses, but most importantly, there will be a lively dialogue here today, because clearly the decision now is on a very partisan basis. The minority will insist that both are legal, while the majority will at least question that both cannot be legal and binding. One has to give. With that, I recognize the ranking member for his opening statement.
Thank you very much, Mr. Chairman, and I thank you for holding this hearing, and to you, Senator Lee, welcome to our committee. Mr. Chairman, if the committee really wants to conduct an even-handed examination of President Obama's recess appointments, we need to look at a much bigger issue first. The unprecedented obstruction by Senate Republicans of the constitutional confirmation process. Republicans have raised constitutional concerns about the President's recess appointments, but the real issue here is the effort of 44 Republican senators to sabotage the mission of the Consumer Financial Protection Bureau. In a letter the Republican senators wrote last May, they declared their opposition to any nominee to head the Consumer Financial Protection Bureau. These Republicans admitted that the President's nominee, Richard Cordray, was highly qualified for the position. As the Attorney General of the State of Ohio, he recovered billions of dollars for retirees, investors, and business owners, and he was on the front lines of protecting consumers from fraudulent foreclosures and financial predators. Senator Mike Lee conceded that Mr. Cordray was well qualified for this position. And I quote, "My decision to oppose his confirmation by the Senate has nothing to do with his qualifications," said Senator Lee. "Rather, I feel it is my duty to oppose his confirmation as part of my opposition to the creation of CFPB itself," end of quote. This gang of 44 Republican senators opposed the creation of the Consumer Protection Bureau. According to existing law, once a permanent director is put in place, the Bureau will have authority to issue regulations protecting consumers from unfair, deceptive, or abusive consumer financial practices by mortgage servicers, payday lenders, debt collectors, private student lenders, and credit reporting agencies. These are exactly the protections Republicans wanted to block. Article 2 of the Constitution says the President shall nominate and appoint officers of the United States, quote, "with the advice and consent of the Senate," end of quote. Nowhere does the Constitution authorize senators to block all nominees, regardless of their qualifications, because they object to the current law of the land and do not have the votes to change it. Constitutional scholar Thomas Mann calls this Republican boycott, and I quote, "a modern-day form of nullification," end of quote, and says, I quote, "there's nothing normal or routine about this," end of quote. As our committee has heard repeatedly, there are millions of American families who are currently in foreclosure, many of them in my district, many of whom were subjected to widespread and illegal abuses by mortgage servicers. nearly 20 million consumers take out payday loans from an industry widely known for its unscrupulous behavior. What is the Republican response? They want to cut the legs out from under the agency Congress created to protect American families from exactly these types of abuses by mortgage servicers, payday lenders, and credit reporting agencies. Today's new concern about litigation arising from the appointment is a red herring. The corporate interests that oppose the creation of the Bureau to begin with are the same interests that are now aggressively challenging the consumer protections in court. As with the Consumer Bureau, Republicans also oppose the entire mission of the National Labor Relations Board and have blocked the President's appointments in an effort to prevent the Board from functioning properly. In short, Senate Republicans left the President with no choice. These recess appointments were the only way to comply with Congress's intent in establishing and maintaining fully functioning agencies. The fact is that President Obama has been extremely restrained in his use of recess appointments. During their full terms, President George W. Bush had made 171 recess appointments. President Clinton had made 139 recess appointments. And President Reagan had made 240 recess appointments. In contrast, President Obama has made just 32 at this point in his presidency. I hope we can ask our witnesses today not only about the President's recess appointments, but also about a much more significant issue: unprecedented obstructionism by Senate Republicans that is intended to cause irreparable harm to the American consumers. And with that, Mr. Chairman, I have a minority report that we produced, and I ask unanimous consent that it be inserted in the record. It doesn't appear to be a report, but the documents you have, we've reviewed them, and I have no objections. They'll be placed on the record. Thank you very much, Mr. Chairman.
Thank you. We now go to our first witness. Our first panel is Senator Mike Lee of Utah. Senator Lee has spent his entire life both studying and participating in our judicial system. As a child, he attended arguments before the United States Supreme Court given by his father, Rex, who was Solicitor General under President Ronald Reagan. Senator Lee later clerked for Justice Alito, both when he was a member of the Third Circuit Court of Appeals and later a Supreme Court Justice. After spending time in the private sector, he was asked to serve as the Assistant U.S. Attorney in Salt Lake and then as General Counsel to Governor John Huntsman. Few people with this type of experience and understanding of our Constitution and our judicial process have served in the Congress. So although Senator Lee is a freshman, he is certainly not new to the questions that the Senate faces and our country faces here today. And with that, Senator, I understand that you're both testifying and willing to take questions. Is that correct?
Yes, sir. Yes, sir.
And as is customary for everyone except, actually required in the rules, except for members of Congress, you will not be sworn in that you're a member of our body. And with that, the gentleman is recognized.
Thank you, Mr. Chairman and Ranking Member Cummings, for the invitation to come here and to address you and the other members of the committee. It's an honor to be here with you today. I'm here to defend the constitutional prerogatives of Congress, and I want to be clear from the outset that regardless of whatever political concerns I might have with these nominations, my overriding, dominating concerns here is not partisan. Rather, it's an institutional and a constitutional concern that I'm here to explain, and then answer any questions that you might have regarding those concerns. President Obama's January 4, 2012 appointments are unconstitutional because they did not comply with the requirements for appointments set forth in the Constitution. Those requirements, I might add, are important because, as the Founding Fathers discussed in that fateful convention in the summer of 1787 that occurred in Philadelphia, the Founding Fathers were unwilling to grant this power on an unrestrained basis to an executive, as they argued that it would not be wise to, quote, grant so great a power to any single person as the people would think we are leaning too much towards monarchy." Close quote. These appointments were unconstitutional because they neither received the advice and consent of the Senate, nor were they made during a Senate recess, the kind of recess cognizable under the Recess Appointments Clause. They are different in kind than previous recess appointments made by any president from any political party in our nation's country. No president has ever unilaterally appointed an executive officer during a recess of less than 3 days. Neither, to my knowledge, has a president of either party ever asserted the power to determine for himself when the Senate is or is not in session for purposes of the Recess Appointments Clause. In making these appointments, President Obama has not, to my knowledge, asserted that his January 4, 2012 appointments can be justified based on the 3-day adjournment that occurred between January 3, 2012 and January 6, 2012. And this is for good reason. Surely any such assertion of the recess appointment power would be unconstitutional. The Department of Justice has repeatedly and over the course of many decades opined that an adjournment of significant length, and particularly an adjournment of 3 days or less, that is, any adjournment that's of insignificant length because it's of 3 days or less, does not constitute a recess for purposes relevant to this Recess Appointments Clause. And the text of the Constitution evidences that the framers did not consider an adjournment like this to be constitutionally significant. It's also significant here that Article I, Section 5 provides that neither House during the session of Congress shall, without the consent of the other, adjourn for more than 3 days. So if an intra-session adjournment of less than 3 days were to be considered constitutionally sufficient for the President to be able to exercise this recess appointment power, it's unclear what, if anything, would prevent the President from routinely bypassing the Constitution's advice and consent requirement and appointing nominees during even weekend adjournments, which routinely involve periods of 72 hours or even more in which the Senate may not be actually in the practice of holding committee hearings and voting and so forth. Instead, in asserting that his appointments are constitutional, President Obama has relied on a memorandum opinion produced by the Office of Legal Counsel in the Department of Justice, also known as OLC. This OLC memorandum asserts that the President may unilaterally conclude that the Senate's brief pro forma sessions, such as those that were held on January 3, 2012 and continued every Tuesday and every Friday until January 23, 2012, somehow do not constitute sessions of the Senate for purposes relevant to the Recess Appointments Clause. This assertion is deeply flawed because under the procedures established by the Constitution, it is for the Senate, and it's not for the President, to decide when the Senate is in session. Indeed, the Constitution expressly grants the power to determine the rules of its own proceedings. To assert that the President has an unconstrained right to determine for himself when the session is or is not in session and to appoint nominees unilaterally at any time he feels the Senate's not responsive as he'd like it to be, even when the Senate is meeting, is to trample upon the Constitution's separation of powers and the system of checks and balances that animated the adoption of the advice and consent requirement. I look forward to answering your questions, and as I answer those questions, I will continue to emphasize again and again that ours is not a government of one. These are real rights upon which the President has trampled. This is power that he's taken that doesn't belong to him. It belongs to the American people. And under our constitutional system, that power is to be exercised by the people's elected representatives in the Senate and not by the President alone. There are people throughout my state and across America who feel powerless, and that's why I've made the comments I have, that this is a lawless action that we need to object to strenuously.
I think, gentlemen, I did not limit you to 5 minutes, but I appreciate your accuracy. I'll now recognize myself for a first round of questions.
We'll call it professional courtesy. I always appreciate it in the Senate when people limit themselves to the 5 minutes as well. So,
well, you know, being a House member, I've noticed that when House members go to the Senate, there's a veil of forgetfulness that we somehow see. Senator, the CFPB passed under Dodd-Frank Isn't it unique or fairly unique in that it receives its funding without appropriation from Congress?
Yes, that's my understanding, is that because this position is embedded within the Federal Reserve, and because the Federal Reserve Bank is not, in a sense, in a literal sense, in the traditional sense, a government agency, but rather a private for-profit corporation, it's not an entity that Congress controls in the sense of controlling its purse strings. And so that is a significant concern that many have harbored.
Right. So you had no other way to ask for reform, consideration, or anything else other than this confirmation. It was an unusual situation in which one of the ordinary powers of the House and the Senate is to not fund something that a previous Congress has chosen to do. But in the case of the CFPB, that's not the case. Is that correct?
That is correct, and in that respect it enjoys an unusual degree of insulation from the normal controls on any government. And that degree of insulation historically has been reserved for despots.
Good word. One of the points that I've been given by Cater on asking unanimous consent that be placed in the record is on their website, they note that 97% of President Obama's nominations in 2011 were confirmed by your body. Is that roughly your understanding?
Yes.
So the fact is, you're practically a rubber stamp to what the President wants, right?
Some of us try not to see ourselves quite that way, but we have been very cooperative in confirming this President's nominees. I, in fact, myself, despite the fact that I've harbored significant policy, ideological, and political differences with many, if not most, of the President's nominees, I have continued to vote for them, and most of them have been confirmed, many with my vote.
So you've exercised advice and consent, and in the affirmative 97% of the time. Let me go to another portion, because you're both personally and as a family historically better informed than we are. Hasn't the Senate exercised this refusal in the past, even at times to the Supreme Court? And hasn't it been the view that if the Senate decided not to have a Supreme Court, all they would have to do is wait for them to die off? That ultimately it is within the power over a period of time for the Senate to choose not to fill vacancies, that is within its historic power, and they have asserted it in the past?
The Supreme Court certainly is on a different plane from other government officials. The Supreme Court, unlike many other government officials, certainly unlike the people who serve in the Nlrb or the CFPB or elsewhere, are not people whose positions are specifically created under and identified in the Constitution. So that's different. But the overarching question you're asking is whether or not the Senate, in its advice and consent function, is required to give its consent, to in fact approve, and it isn't. And that is the Senate's prerogative.
So both at District Court, Circuit Court of Appeals, and actually at the Supreme Court, they have chosen simply not to act on presidential appointments in the past, and by doing so, let them hang until the President withdrew them, or the nominee went somewhere else, or the President's term expired, or he found somebody else to appoint. Isn't that correct?
In many, many instances, more instances than I can count.
Now, ambassadors are one of the confirmations that you do in the Senate. And if we do not have an ambassador, we in fact have a lower standing in that foreign country and a lower ability to have a presence around the world. Isn't that true?
That argument has been made, and I suspect there's some truth to it.
And isn't it routine? And they're certainly envisioned in the Constitution. They're not just some affectation of the administration's last Congress. So isn't it true that it has been the practice of the Senate under Senator Reid sometimes simply to say that nominee is dead on arrival and go find somebody else and not call for a vote?
Yes.
Isn't it true that often nominees are pre-vetted before they're put up so as not to embarrass them, and in fact there's a whole discussion because they so want to not have that controversy?
That is also correct. Well-known fact that this occurs, and with good reason.
With good reason. So I guess a couple last questions. Motion to adjourn in the Senate. I'm a different body here, but it's in order here at any time. Was there a motion to adjourn by the Democrats issued? Did they try to adjourn?
My understanding is that we could not adjourn because, consistent with Article 1, Section 5 of the Constitution, we were required to obtain the consent of the House of Representatives to adjourn and before adjourning for any period of time longer than 72 hours. Given that we didn't receive such consent, the Senate was unable to adjourn for any period of time longer than 72 hours, and so we continued holding pro forma sessions, basically every 72 hours throughout that period.
But let's talk about pro forma sessions. The last question very quickly. Every third day, who got in the chair over in the Senate? Was it a Republican?
Normally a Democrat, is my understanding.
Normally or always?
Always.
So Senator Reid had to put a Democrat in the chair to hold the pro forma session every third day, and he did so.
Correct.
Thank you. I yield back and recognize the ranking member for 5 minutes and 49 seconds.
Thank you very much, Mr. Chairman. And again, Senator Lee, I want to thank you for bringing these concerns before us. As you could tell from my opening statement, I'm concerned that a large number of senators tried to block a candidate who is extremely qualified for a post because they disagree with the law Congress passed creating the Consumer Bureau. On December 7, 2011, your office issued a press release that stated, and I quote, "My decision to oppose his confirmation by the Senate has nothing to do with qualifications. Rather, I feel it is my duty to oppose his confirmation as part of my opposition to the creation of the CFPB itself." My question is, the Senate's role is to give advice and consent. Senators, just to be clear, Senator, just to be clear, you don't have any problem with Mr. Cordray, did you, Cordray?
I don't have any personal problem with him. I'm sure he's a wonderful human being.
You felt that he was qualified for the job?
I feel that he possesses professional qualifications which might well serve him well in a variety of government positions.
I'm going to put up slide 5 up on the board. Seaboard and Gray, slide 5, please. Seaboard and Gray, who was the White House counsel to President Bush, will be testifying on the next panel of this hearing. And his view is that your actions would be an unconstitutional act for a senator. Let me read to you what he said. And it says, and I quote, "I believe the use of Senate cloture rule to permanently block nominations conflicts with the Constitution's advice and consent clause." So, Senator Lee, is your message to Mr. Gray that he doesn't know his constitutional law?
I certainly would never say that. I have enormous respect for Mr. Gray. I consider him a friend. I also consider him something of a role model as a constitutional scholar, and I admire his work. I'm not sure of the totality of the circumstances in which he made that comment, but let me say this. My belief is that because Congress is a legislative body consisting of elected officials, and those elected officials are retired in increments, especially in the Senate where we have elections only every 2 years. You often have a set of laws that one body has to deal with. In many instances, you have members of a new Congress that didn't vote for a previous law. It's not at all uncommon, for instance, to have a law that creates a government office in one session of Congress that a subsequent Congress refuses to fund, or refuses to fund part of its actions. That happens from time to time. Now, you might have a Senate that decides not to confirm somebody to a particular position, perhaps because of the qualifications of the individual, or perhaps they have concerns about the office or the power that officer might wield. And I believe that it's not improper for Congress to raise those concerns, raise substantive concerns about the office itself when going through the nominations process. It is, at the end of the day, the Senate's prerogative to confirm or not to confirm, and there is nothing in the text, the original understanding, or the history of the Constitution that suggests that the Senate's prerogative to provide advice and consent to presidential nominations means that the consent, in fact, has to be granted.
So, in other words, if a senator disagrees with the law, then it's your opinion that they are within their rights under the Constitution to basically say, I'm not going to vote to confirm a nominee. Is that right? Because
yes,
the underpinning law is that?
Yes, and in precisely the same respect and for precisely the same reasons that a senator or a congressman for that matter, might refuse to vote to fund a particular office that was created under a previous law adopted by a previous Congress. That is not only not improper, but that is part of what it means to live in a constitutional republic in which laws are made and government programs are funded only by regularly elected officials who stand for re-election and may lose election after a while.
In addition, on February 2, 2005, Senator John Cowell, one of your colleagues, made the following statement on the floor regarding the Gonzales nomination, and he said, when someone is qualified and has the confidence of the President, unless there is some highly disqualifying factor brought to our attention, we should accede to the President's request for his nomination to confirm the individual. What's your opinion on that, what he said?
Well, again, I make it a point not to speak for my colleagues. I don't know the totality of circumstances in which my friend Senator Kyle made that statement. But I will say, first of all, that any senator may decide to grant or withhold his or her vote to confirm or not to confirm anyone for any reason, just as he or she is free to vote or not vote for any particular budget or appropriations act or anything else. Secondly, and perhaps more importantly, the fact that there is delay, the fact that there has been delay in confirmations in every Senate with every presidential administration, Republican or Democratic, going back decades, in fact, going back throughout the entire history of our republic, does not and cannot ever excuse the President of the United States in thumbing his nose at the U.S. Constitution. That is what's happened here. That's what we're talking about today.
So senators started blocking all the prominent President's nominees because they disagreed with the laws that Congress passes. We would essentially have a form of nullification that could shut down the government, and that clearly is not what the framers intended.
Well, I'm not sure that I can agree with that statement. Every Congress has the power to shut down the government should it choose, subject, of course, to what the electorate wants. If a Congress chose to shut down the government, my guess is that that would be extraordinarily unpopular, especially if it extended for a duration of more than just a few days. Yeah, the Congress has the power to do all sorts of things. And the fact that the Senate could exercise that advice and consent power irresponsibly doesn't justify the President in circumventing those very same constitutional restrictions that give it that power.
Thank you, Mr. Chairman.
I thank you. And if I can make a clarification for the record, Ambassador Gray was in the first Bush administration. You said President Bush. I want to make sure everyone knew it was not the immediate past. And with that, we recognize the distinguished gentleman from South Carolina, Mr. Gowdy.
Thank you, Mr. Chairman. Senator Lee, welcome. Thank you for being with us today. Who has standing to challenge this?
Well, if you're talking about Article III standing for purposes of determining whether a case is justiciable in a Federal court, the most likely type of party that could establish standing would be a party aggrieved by an order, a decision carrying the force of law by either the National Labor Relations Board or the Consumer Financial Protection Bureau. Once such an order has been issued and you have an aggrieved party, someone could, in theory, take that case to a Federal District Court and say, I have an injury in fact that's fairly traceable to the conduct of the NLRB or the CFPB, and it's the kind of injury that could fairly be redressable in court.
Do United States Senators have standing to challenge the recess appointments?
While there may be some disagreement on this of the authorities that I've consulted, including those based on the Supreme Court decision in Raines v. Byrd, seem to suggest that U.S. Senators are likely not to have standing to bring the case in their own capacity, but they certainly could, in all events, participate as amici curiae.
There is often a talk of precedent and stare decisis, particularly when people like the decision initially. They don't tend to talk about precedent and stare decisis as much when they don't. My concern is whatever the analysis we have of the recess appointment clause should be the same irrespective of who the President is and what party they are in. Can you talk about the historical treatment of what a recess meant and what a better rule is going forward? Because it strikes me that if the person in the chair were taking a nap under the President's analysis, he could make a recess appointment, or if y'all were out to lunch for a couple of hours. What's the difference between 3 hours and 3 days? So what's historically been the rule, and what's a good rule going forward, irrespective of who the President is?
That's a great question, and I want to emphasize the concern embedded in your question here, that the answer can't simply be that the President may decide on his own accord when the Senate's in recess. If he regards that the Senate is doing insignificant work, for instance, if he decides that whoever is sitting on the presiding officer's chair is going to sleep, or that they're likely not to do any work, that's dangerous. That creates a slippery slope in which he could decide to make recess appointments overnight or over a weekend or something like that, and that certainly can't be the case. To answer your broader question, precedent has been established in recent decades, basically over the course of the last century. Before that, I think it was a little more informal, but we have had substantial precedent evolve over the last century. We had in the early 1900s a series of recess appointments made by President Theodore Roosevelt, 167 recess appointments made in the seconds between the end of one Congress and the beginning of the next Congress, just in between gavel taps, basically. The Senate Judiciary Committee convened a panel and conducted a formal investigation to determine what the rule ought to be. And our custom and practice, as it's evolved over the intervening century, has been based in part on their analysis. Here's one of their conclusions, and I quote from their 1905 report. The framers of the Constitution were providing against a real danger to the public interest, and not just an imaginary one. They had in mind a period of time in which it would be harmful if an office were not filled, not a constructive, inferred, or imputed recess as opposed to an actual one. So in other words, they're saying you can't use an overly technical set of logic in order to reach the conclusion that you've got a recess. Now, that conclusion was followed up by an Attorney General's advisory opinion by Attorney General Doherty, which was issued in 1921. And among other things, in that report, he explained that regardless of exactly where you draw the line, he said, under no set of reasonable circumstances can you infer that a recess or an adjournment lasting less than 3 days could be deemed a recess for purposes of the Recess Appointments Clause. He went on to say it's probably too short, even if you take it out to 7 days or to 10 days. And ever since then, our analysis has been informed by those positions, that if nothing else, we look back to those two clauses of the Constitution we talked about earlier, Article 1, Section 5, and Article 2, Section 2. Article 2, Section 2 says the President has this power during a recess. Article 1, Section 5 says that in order to adjourn for more than 72 hours, the Senate has to get permission of the House. So that has evolved as a sort of safe harbor. If we don't have permission from the House, or for whatever reason we don't get it, then we're not in recess because we're having to convene every 72 hours. The fact that we might not pass laws doesn't mean that we can't. We, in fact, did pass a very significant law on December 23rd in one of those pro forma sessions, just days before these recess appointments were made. So it is wrong to suggest, as the President's Office of Legal Counsel has suggested in advising him, that those pro forma sessions are meaningless for constitutional purposes here.
Mr. Chairman, I have additional questions, but I am out of time, so perhaps one of my colleagues will take mercy on me later on.
One can always hope. And with that, we recognize the former chairman of the full committee, Mr. Towns, for 5 minutes.
Thank you very much, Mr. Chairman. I appreciate
And if you'd like to yield to the gentleman from South Carolina at any time, he's available.
Yeah, I don't think I'll do that. But let me just say that I really appreciate the Senator coming over and to share with us. But, Mr. Chairman, I yield back the balance of my time because I really want to get to the witnesses. You know, I really do, and I'm eager to get to the witnesses, and I hope my colleagues are too. I yield back.
I thank the gentleman for yield back. We now go to the gentleman from Texas, Mr. Farenthold, for 5 minutes.
Thank you, Mr. Chairman. Thank you, Senator, for being here. While I was home over the Christmas holidays and during this this time frame, and after the President made these appointments, I got a great deal of email from my constituents, asking, how could you let this happen? How do you fix this? What do you do? I mean, there was a real frustration. I think the American people got, on a common sense basis, that we were not in recess when we were meeting pro forma every 3 days, when we passed very significant legislation in the form of the payroll tax holiday that the President himself was calling for us to pass during these pro forma sessions. So my question to you is, I'm not going to get into the nitty-gritty of whether we were in recess, and I think the American people, anybody with a lick of common sense, gets that we were not in recess. But where do you go from here? What are our options in dealing with these people who are taking taxpayer money, making critical decisions affecting this country, and have bypassed the advice and consent of the Senate, as I think is required by the Constitution? I mean, what are some of our options here? What can we do? It's clear courts don't like to get involved in these separation of powers issues. You answered Mr. Gowdy's question about standing. I mean, where do we go from here? Do we defund the positions? Well, that'll never really get passed unless we can bury it in some other bill. I mean, we can't impeach them, I don't think, because they haven't committed any crimes. Do we amend the Constitution to make this problem not happening? And where do we go from here?
Well, first of all, thank you for sharing that set of remarks about what you've heard from your constituents. It's very much consistent with what I've heard from my constituents in my state, which is that people are feeling frustrated. They're feeling a sense of powerlessness. They're feeling the sense that power that belongs properly to them, the American people, has been exercised. It's been taken by someone to whom it does not belong. The President has taken power that belongs to the people and is authorized to be exercised only by those duly elected to the United States Senate. And so something does need to be done, and that's why I've drawn the attention to it in recent days that I have. That's why I've said that for my part, in my role as a Senator, although I've cooperated and cooperated happily with this President, even though he's appointed a lot of people with whom I have significant political and philosophical disagreements, I've recognized he is the President. He did, in fact, win an election. Elections have consequences, and I've confirmed most of those people who have come before me. But for me personally, that changes now. My response to that, my duty to the Constitution, based on the oath that I took to it just over a year ago when I took office, I think requires me to stand up for these constitutional prerogatives and to show the President that unless or until he rescinds these unconstitutional appointments and allows them to be considered under regular order in the Senate, he's not going to enjoy the same degree of complete cooperation that he's had. Other responses might include an action in the courts, notwithstanding the doubts surrounding whether Senators have standing independently. Senators can, and I anticipate many will, participate as amici curiae in judicial actions that would be brought by other parties with standing. I think there is some possibility the courts could act. One of the problems is that the courts act relatively slowly, and it seems somewhat unlikely to me that the courts will issue relief in the time that's required, because these recess appointments will be valid only through the end of the year, and if the court acts after that, it's sort of water under the bridge in a sense. Other options would include, as you've suggested, options that might involve defunding these offices. Certainly in the case of the NLRB, we have to remember that the President can't fund anything on his own. He has to rely on Congress. Congress has the power of the purse. And the House of Representatives, in the first instance, holds the power of the purse. That is certainly an option. There's problems that arise out of the fact that the CFPB is embodied within the Federal Reserve Bank. We might want to look at a change in substantive law and the fact that we've given this office to that entity, and we've given funding responsibility to an entity that's not within our funding control. These are the primary levers that we use. In addition to all of those, I think it's important that we make sure that this is considered in the political discussion in the upcoming elections, both presidential and congressional. Because we in America have to entrust that those we elect to office, particularly the chief executive officer position, will respect the limitations on their power. Ours is not a government of one. And for this President to pretend otherwise is an insult to the Constitution, and it's an insult to the American people.
Would the gentleman yield?
Yes, sir.
By the President doing the appointment on January 4th, not January 3rd, Isn't it true that these individuals will enjoy a 2-year term, not a 1-year term?
That is not my understanding. So the recess appointments clause in Article 2, Section 2 provides that recess appointees will remain in power until the end of that session of that Congress. So it's interesting. We held our first session of the second session of the 112th Congress on January the 3rd, 1 day before the President made these recess appointments. So it's my understanding that they will continue in office, assuming they're not invalidated in some other way, through the end of this session, which will last through the end of this year. We'll start a new Congress, of course, in January of next year.
I see my time has expired.
I thank the gentleman for giving me what was left. We now recognize the ranking member of the full committee, Mr. Cummings, for 5 minutes. I'm sorry, you did. We now recognize the gentleman from Massachusetts, Mr. Lynch, for 5 minutes.
Thank you, Mr. Chairman. Senator, I just want to say how pleased I am to have you come before the committee. I appreciate your words and your cooperation, your assistance with this matter. I do have to acknowledge, though, you are not under oath, so this is really just a chat. And it's one that I'm enjoying, but we do have another panel of witnesses that I would like to get to, so with all due respect, I'll yield back the balance of my time. Thank you, sir.
Thank you.
Well, that was quick.
Happy to take an oath if you want me to, by the way.
You know, you took an oath already, Senator, and
Indeed.
we think that's more than sufficient for ourselves and for the other body. We now go to, give me a second to make sure I don't bypass anyone. We now go to the gentleman from North Carolina, Mr. McHenry, for 5 minutes.
I thank the Chairman. Senator Lee, thank you so much for being here. I certainly appreciate your testimony, and thank you for the work that you're doing, the heavy lifting you're doing in your first term in the United States Senate. With that, I'd like to yield the balance of my time to the gentleman from South Carolina, Mr. Gowdy.
I knew you'd get lucky from a fellow Carolinian.
Well, Congressman McHenry has always shown graciousness toward me, and I appreciate his yielding. Thank you for that. Senator, how were you possibly to have vetted the NLRB putative appointees given when the names were submitted to the Senate?
Yeah, thank you for raising that, Congressman Gowdy. With regard to 2 of the appointees to the NLRB, their names were submitted just right before the Christmas holidays, and just days before, in fact. And as a result, they had not gone through the committee process. They hadn't been vetted by any committee. We hadn't had time to set up a single committee hearing. And so that in and of itself ought to draw attention to the legitimacy of the procedures, the legitimacy of the constitutional analysis that led to these unconstitutional recess appointments. It really is a stretch, to say the least, to say that any of these are legitimate recess appointees, and particularly so with regard to those. This underscores the point. This was not justified, cannot be justified, by the fact that inevitably in any Senate confirmation proceeding for any nominee there may be some delays. There have been under every administration, in every Congress, in every Senate that I'm aware of ever. And the fact that that happens doesn't mean that the President can just ignore the Constitution. But that's especially so where they were given to us just days earlier, and we didn't even have time to vet them.
So you get the names on December the 15th, and what, 2.5 weeks later, he makes a recess appointment and says that the Senate's not doing its job?
That's correct.
And with respect to the Republican appointee to the NLRB, could Senator Reid have set that for a vote? I'm not familiar with how the Senate works, but that name had been in the Senate for some time. It strikes me that if Senator Reid were concerned about whether or not there was a quorum on the NLRB, he could have set that, and he did not set that.
As the majority leader, he does, in fact, control the Senate schedule and the Senate vote schedule, and he could have set that for a vote, and yet he did not. And that opens up another issue, which is that at any given time, we can even do these sorts of things through a pro forma session. We have on occasion approved people by unanimous consent in a pro forma session. and that has been done in the past. It could have been done at the time. The fact that it didn't occur hardly means that we were not available to act on these.
Well, as I shared with you before, Congressman McHenry was so gracious to give me some extra time, my real concern is whatever we decide this analysis is going to have to be equally applicable whether we like who the President is or we wish we had another one. So it just strikes me that we have created something of a ratchet, because once you define it, it is very hard to expand it once you limit it. And it now seems to me the rule is we're going to give you 2.5 weeks to vet our nominees, and if you don't, then you're not doing your job. And if you're out for 3 days, that's a recess. And if we like the laws you pass, like the payroll tax extension, then you're not in recess. But if we don't like what you've done, you are in recess, which the political gimmickry, the Constitution really should be immune from political games. So can you speak to how you were in recess, but yet you also passed this payroll tax extension upon which the Republic hung in the balance, if you listen to the rhetoric? How could you pass that, but yet still be in recess?
Well, of course, we couldn't. We had to be able to act, and we did, in fact, act. And we acted on December 23, 2011, to pass that into law. The President demanded that Congress act. The President subsequently praised the Congress for moving into action quickly. He signed that legislation into law promptly. He recognized the legitimacy of Congress's actions, notwithstanding the fact that they were conducted, at least on the Senate side, in a pro forma session on December 23rd, notwithstanding the fact that previously we had anticipated that there might not be any formal business conducted. There was. And that indicates the fact that we were, in fact, open for business, as we were required to be under the Constitution, not having received the consent of the House of Representatives to adjourn for a period of more than 3 days. This emphasizes my broader point, which is that my concern is neither Republican nor Democratic. It is neither liberal nor conservative. This is politically ecumenical. This issue is simply an American one rooted in the rule of law and the U.S. Constitution, to which we've all taken an oath. It is that we can't, as an institution, as a country, afford to allow one person to exercise power that does not properly belong to him, that the people have not properly given him. And that is what happened here. So I will be just as hard on any Republican President who dares try this nonsense as I am on this President.
Thank you, Senator. Thank you, Mr. Chairman, and the gentleman from North Carolina.
I thank the gentleman. We now recognize the distinguished lady from the District of Columbia, Ms. Norton, for 5 minutes.
Thank you, Mr. Chairman, and I want to thank Senator Lee for appearing today. I just want to say I might have found the discussion edifying had there also been present a senator who supported the appointments during this recess, since all senators are notorious for jealously guarding their institutional prerogatives. But absent that, Mr. Chairman, I'd as soon get on to the next panel.
I thank the gentlelady. I will note that we took all senators who asked to be here. And with that, we recognize the gentleman from Tennessee for 5 minutes, Mr. Deschalets.
Thank you, Mr. Chairman, and thank you, Senator, for being here. Unfortunately, I have a conflict with another hearing, so I'm going to yield my time back to the good Chairman, Mr. Issa.
I thank the gentleman. Now it's Tennessee and California that are teaming. Senator, I did want to follow up on a couple of questions. You mentioned earlier Teddy Roosevelt's famous appointments, but those were specifically when the Congress went gavel to gavel. In other words, during the anticipated historic change of sessions. Did the President have that option in this case, or could he have had that option to do it on January 3rd? Because wasn't there, in fact, a moment between sessions?
Well, I don't regard there to have been an opportunity for him to issue an actual recess appointment. But I should point out that that hypothetical does get at a different set of facts. That deals with what you might call an inter-session recess appointment.
Right. And isn't that one in which the Court has spoken?
Well, that is one in which a court has spoken. I believe you might be referring to the 11th Circuit decision in that regard. But yes,
but that would be one in which the President would know the likely outcome, at least historically, right?
Perhaps in a different set of circumstances if they otherwise would support the conclusion that we were in recess for purposes of the Recess Appointments Clause. But that would be called an inter-session appointment, and this was an intra-session recess.
But the President clearly waited. He waited till January 4th. It didn't come to his mind. The opinion he sought didn't just come in on January 3rd. He had, with malice and forethought, if you will, maybe malice is a little unkind, but with forethought and planning, he planned to do it after January 3rd from all indications.
I strongly suspect that this was not an arbitrary decision on the part of the President. He's a careful person who is familiar with the Constitution, and I'm certain that this was deliberate.
Isn't he sufficiently familiar with the Constitution that he had the opposite opinion when he was in the Senate that he now has as President?
I think he got it right the first time and should have stuck with his first instinct.
The Presidents often say they grow in office, and perhaps he simply grows out of the office of the Senate and the respect for that body, which is, quite frankly, my personal opinion, that it's a lack of respect for the body he once belonged to. Let me go through just one or more points, because as a House member, not having served in the Senate, they let me come over there once in a while and lobby you all, but that's about it. You have some interesting rules that are a little different than ours. First of all, a motion to adjourn is still a high standard, or a low standard, if you will. In other words, it's immediately taken. So a motion to adjourn is always in order and could, in fact, at any time, any member could have moved to adjourn, even during the pro forma session, unless there was a specific exemption agreed to, right?
That's correct.
So any member of the Democratic Party, not just Senator Reid, could have moved to adjourn in order to create a legitimate recess, correct?
That's correct. I suppose that doesn't account for the need that they would have to get permission from the House to adjourn for more than 3 days. But separating that question out, yes.
But, of course, Senator Reid could have put no one in the chair on the third day. Isn't that correct?
Yes.
No power could have forced him to be in the chair.
I'm not familiar with any court or any precedent from the Supreme Court that would have led to a court injunction telling Senator Reid he had to do that.
So every single member of the majority in the Senate, including Senator Reid, had the ability to create a different set of circumstances and did not.
Yes.
Additionally, anything that was passed by unanimous consent, correct?
Correct.
So the fact is, the December 23rd vote, any member of the Senate, yourself included, could have come and taken that down. It was an affirmative decision that that agreement was going to happen. It wasn't an accident. It wasn't like the UC was a surprise and people just weren't there.
That's correct. Any one of us could have objected and stopped that from proceeding.
Now, you're a little different in the Senate than the House. I know that because I've worked with Senate staff. Senate staff vets, as I understand, every one of these UCs, and unless the Senate staff responsible to the Senator either speaks to the Senator or makes that commitment for some reason on behalf of the Senator, UCs don't happen, right?
That's correct.
You have the process of holds, if you will. Everything starts with a hold and then you release them.
Yes.
So if there had been an actual request for a vote during the pro forma session, a request for a UC, that would have it would have come up. Each of these appointees could have come up as a request for a UC, and a member would have had to show up physically and object to that appointment, and Senator Reid held no such vote.
An objection could have been made. That is correct.
But a Senator would have to be there to make the objection.
Well, that's probably a discussion for a different day. An objection probably could be made. A hold probably could be imposed on a unanimous consent request without actual physical presence, but the objection would likely have then triggered a requirement for physical presence.
And my borrowed time has expired, but you've been very illuminating. With that, we go to the gentleman from Virginia. And before we go to Mr. Conley, I would ask unanimous consent that, I apologize, that Democratic objections to recess appointments, which is a 5-page document be placed in the record, including the January 24, 2012 quote from the gentleman from Virginia, Mr. Conley. Without objection, so ordered. The gentleman is recognized for 5 minutes.
I thank the Chair, and the Chair is right in introducing into the record my longstanding view that recess appointments by both presidents of both parties have frankly long been abused. I don't believe that the Constitution envisioned recess appointments being routine things. They were designed for a time when Congress was not in session for long stretches of the calendar. But that requires bipartisan cooperation to fix that problem. It has nothing to do with this President, per se. It is a longstanding institutional and constitutional issue. I would hope we could find bipartisan common ground. And so I actually find myself sharing many of your misgivings, Senator Lee, about a recess appointment. But having said that, I've listened respectfully to your point of view, and I respect it. I hope you will listen to mine. I believe that a statement by 44 Republican senators in the United States Senate announcing that they're going to try to thwart the implementation of a duly passed law. Constitution envisioned how a law gets passed. It never envisioned that you got a second extra constitutional bite at the apple to thwart its implementation when you didn't have the votes to defeat it. And I believe that, frankly, that letter precipitated this issue, and that you got what you deserved. And it set us all back, frankly, for those of us who have, as the Chairman just indicated in introducing into the record, misgivings about recess appointments as a separate issue. And so I guess, with all due respect, consider this a rebuke, because I think it's an extraordinary thing, a priori, to announce no matter what, no matter the virtues of the appointees, no matter the fact that we have to respect that a law was duly passed and signed into law by the President of the United States as the Constitution calls for, we're going to thwart it. We, in advance, are announcing we're going to oppose all appointments to prevent the implementation of that provision of the law. And I just think that's wrong. You win, you lose, fair or square. And you've indicated that many of your constituents are nonplussed about this action. I would hope they'd be equally nonplussed at the extra constitutional decision by you and so many of your colleagues to thwart a duly implemented law. That's my opinion, and I yield back.
Before yielding back, would the gentleman also want to ask about the NLRB? You dealt with one. Did you have questions on the NLRB appointments?
I don't have any questions, Mr. Chairman. I just issued my statement, but I would say that the same applies, frankly, to that as well.
Gentleman yields back. We now go to the gentleman from Michigan, Mr. Amash, for 5 minutes.
Thank you, Mr. Chairman. I simply want to thank one of my favorite senators, Senator Lee, for being here, and I'm going to yield my time to Mr. Ginta. Thank you.
I thank the gentleman. I thank the senator for being here this morning. And 2 points for the record. I think he is here first because he asked to speak on this subject matter, and we want to hear what he has to say. Secondly, he's got a rather unique perspective on these issues with his background in having opportunities to clerk in the Third Circuit Court as well as the Supreme Court, is my understanding. So I thank your comments, for your comments. I want to be clear. I don't support what the President did. I've looked at this issue. I have spent quite a bit of time looking at precedent, and I think this President, in this circumstance, overstepped his authority. My understanding, and please correct me if I'm wrong, is that it is the Senate and only the Senate, not the President of the United States, that has the capability to determine when the Senate is in recess. Is that your understanding?
Yes, that's my understanding based on the text of the Constitution, based on the history of the Constitution, its original understanding, and on custom and practice as it's evolved over the last 2 centuries. We are expressly given the power, as is the House, to determine the rules for our own procedure and internal governance, and we do that.
So the President is relying, in making this recess appointment, on the Office of Legal Counsel's justification in a memo that they issued. And their memo essentially said that the OLC effectively asserts that the President may unilaterally determine if and when the Senate is in recess for purposes of exercising his recess appointment power. So my read is that the President is looking at his legal counsel's opinion that says he can decide when the Senate is in recess. However, there's clear precedent that states only the Senate has that authority. So that's problem number one with this process. The other 2 points I'd like to make is that back in 1993, during the Clinton administration, the Department of Justice filed a legal brief in federal court for the District of Columbia, arguing that unless a recess lasted for 3 days, a president could not make an appointment more than 3 days. The third point I'd make is in April of 2010, then Solicitor General Elena Kagan acknowledged before the United States Supreme Court that, quote, the Senate may act to foreclose the President's recess appointment power by declining to recess for more than 2 or 3 days at a time over a lengthy period. Presidents have not in recent decades made recess appointments during intra-session recesses lasting fewer than 3 days. So there is most recent opinions and precedent set by those who would likely support the philosophies of this President, who have acknowledged that what this President is doing is wrong. And to speak to what the gentleman from Virginia mentioned, is that this should be about appropriate powers of the executive branch. It should not be about Republican or Democratic philosophies. It should be about the country and what is good for the country. And I believe that all of us in the legislative body as well as in the executive need to adhere to the precedents and the laws and the rules that we have established. And without doing that, these bodies cannot gain greater credibility with the country. And I would submit that it makes sense for the President of the United States to acknowledge in this circumstance he erred and that he should resolve it to reinstate the faith in the process that we have.
If I can respond to that, thank you very much, Congressman. Yes, I share your concerns, and I've reviewed the Office of Legal Counsel's 23-page single-spaced memorandum. It is well written. It's well researched in the sense that it points out the precedents, but it reaches the wrong conclusion, and it reaches a conclusion that is at odds with the very precedents to which you referred and to the very logical positions to which you referred. And as I'm responding to that, I'd like also to respond simultaneously to Congressman Connolly's point, because I think they kind of lead to the same conclusion here. I understand and I share the frustration that so many Americans have expressed over the fact that there are delays at times, sometimes long delays, sometimes delays that don't get resolved until after that Congress is over or after that President is no longer in power. That is frustrating, and it's especially frustrating to those whose names are on the line to be confirmed. As frustrating as this is, constitutional government is necessarily, by its very nature, frustrating. It was designed to be frustrating in the sense that it was designed to make sure that it wasn't so efficient that we just passed laws really quickly. Efficiency doesn't always lead to liberty, and frequently it leads to exactly the opposite position. So the fact that this process is frustrating, the fact that there are at times delays, the fact that the delay has sometimes been abused, even though it's the prerogative of the Senate to do that, does not and cannot ever justify circumventing the Constitution and just saying, this is really necessary, this is really important, I'm therefore going to do this. At every turn, when we've tried that in this country, it hasn't ended well. And I'm determined not to allow that to happen here. I'm not about to stand idly by as this precedent gets established, knowing full well that it could, and unless we do something about it, it will be abused in the future, not just by Democratic presidents, but by Republican presidents.
Well, I thank the Senator for your comments and thank the gentleman from Michigan for yielding.
I thank the gentleman. Mr. Welch of Vermont.
Well, I thank Senator Lee for being here. I just have a short statement. You know, there's an air of unreality about this for me, and I find this extremely discouraging. Mr. Gentz is right. People want us to abide by the rules. Senator, you're making a very passionate statement about the rules. But, you know, this institution of Congress and the House and the Senate is seen rightly by Americans as totally dysfunctional. And we are in the process of proving the point. I mean, there is a fundamental difference between deliberation and destructive delay. That's my view, and I think it's the American people's view. The rules that we work by in the House, the rules that you work by in the Senate, those are designed by senators and House members, and they suit our interests. They don't get elevated to the level of constitutional rights. They're rules that oftentimes serve the interest of the majority party in both bodies. The problem we're having here is Democrats can't work with Republicans in either body. The Senate, I believe, is seen as having a series of procedures that have one purpose, and that is to delay and not get to an answer to move forward on the business that America needs to be done. I mean, it is an astonishing spectacle what we're doing in this Congress in refusing to do the people's business. We haven't passed a budget. And I don't point the finger of blame at one party or the other. This institution just isn't working. I mean, it has had a history in the past where it's been able to make decisions. So when we have what sounds to me like a very academic discussion, and I put myself in the seat of a constituent of mine who's wondering, what is it we are talking about? We have not passed a budget. That is disgraceful. And 2 years ago when the Democrats were in the majority, the finger of responsibility was pointed by my colleagues on the Republican side at our failure to do it. Now the Republicans haven't been able, who are in the majority, at least in the House, not in the Senate, but have an active and powerful minority, we haven't been able to pass a budget. This is very destructive. So at the end of the day, you may be right in your legal argument, but it is not going to move this country forward whether you're right or President Obama's right. So I just think we've got to move past these procedural maneuvers that we create to allow us to assert our will and make decisions, do it in an up or down vote, allow there to be clarity for the American people where each of us stands. If they don't like the vote that we made, they've got the opportunity at the next election to send somebody else here to do it. So thank you for being here, but I don't think we're getting anywhere.
If I can respond to that, Congressman Welch, I appreciate your comments. Your concerns are very legitimate, and I share very many of them. Let me reemphasize that, the delay is built into the system. Part of the delay that's built into the system is constitutional. Part of it is based on the rules of each body. And the rules of each body are, of course, constitutionally the prerogative of each body. The President of the United States, when he gave his State of the Union address last week in your chamber here, told us that what he'd like is to see a rule change and a policy change in the Senate that will lead to an up or down vote for each nominee within a finite period of time. That, of course, is ultimately a decision for the Senate to make. But I think that is where the debate and discussion over this ought to be. In other words, the frustration that he has, that members of this body have, that members of the Senate have, or the American people in general have, ought to be directed toward a discussion about whether or in what way the Senate might change the rules of its procedure, and not towards saying we're frustrated with those rules, we're frustrated with the way that they manifest themselves in delay, and we therefore want the President to ignore the Constitution. That final conclusion isn't the natural, logical, legitimate product of saying we're frustrated. We ought to have a discussion about the rules themselves and not simply capitulate and say, let's give up and the President can violate the Constitution if he wants.
Gentleman yields back. Mr. Genta is recognized for 5 minutes.
Thank you, Mr. Chairman. I would just simply add that while I don't disagree with the gentleman from Vermont's comments relative to let's focus on the legislative side on action and moving the country forward relative to policy, it also is equally important that we reiterate to the country that we're following our own rules. I mean, I think we teach our families, our children, that rules are important. I get to go home on weekends and see my third-grade daughter's basketball games, and they're rules. And it's a very important lesson to teach our children to abide by them. And if we simply can't do it as what I think is an incredibly important body, Congress and the President, then what kind of message is that sending to the nation? So I certainly appreciate my colleague's position relative to the legislative requirements of both bodies, and I would agree with him and urge both bodies to work together on a thing like a budget, the appropriations bills. By the way, maybe you could remind the Senators that we did in the House pass a budget last year, and we are going to pass another one this year, and we'd love to have the Senate respond. But I'd like to yield the remainder of my time back to the Chair.
I certainly appreciate my colleague yielding. You know, it is interesting. My colleague on the other side of the aisle said your legal argument might be right. It's sort of an interesting point of debate. You know, what's the Constitution among friends, right? That old saying. Let me ask you a couple basic questions. How many Republicans are there currently in the United States Senate?
47.
And is 47 senators, is that a majority of that body?
No.
Interesting. Okay. After the 2008 election, I know you weren't a senator, but weren't there 60 Democrats in the United States Senate?
Yes.
And if you have 60 of any senators together, do they even have to speak to the other 40 senators in the elevator?
Not much.
Right. So let's just understand historically where this president has been. He had a supermajority in the United States Senate after the 2008 election. He was able to pass his stimulus through the House, through the Senate, didn't get a single vote from Republicans in the United States House. It became law. This president has had a majority in the United States Senate for 4 years. He has had a majority, a supermajority in the United States House. I mean, well, let me restate that. He had 59% of the United States House after the 2008 election. So this idea that he's complaining about the Congress's inaction is pretty absurd. So let me go to the CFPB. Okay. Now, in the president's lawyers said that there is a great risk, a litigation risk on that anything the CFPB does would be challenged based on the constitutionality of this appointment. Anything the National Labor Relations Board does could be challenged legally based on this president's, I think, unprecedented action. Looking at that litigation risk and the amount of uncertainty that creates for small businesses, even big businesses, and the impact that has on the economy, that is sort of the net impact of this debate that we're having. Now, I know you're a constitutional scholar, but I also understand you represent the folks in Utah who are concerned, like my constituents, about jobs. This does have an impact on the American people in a real way. It is not some academic debate. But you referenced the fact that the Senate is in session every 3 days when you're in pro forma session. Why if the House doesn't agree to adjourn, why does the Senate meet every 3 days? Where does that come from?
Article 1, Section 5 of the Constitution provides that we may not adjourn without the consent of the other body for a period of time longer than 3 days. And because the House of Representatives didn't grant us permission to adjourn for a period of time longer than 3 days, we had to continue to meet every 3 days.
Okay. And so when does this date back to, this action by the Senate in practical impact? I know it was written.
The last vote, the last roll call vote on the floor of the Senate prior to the Christmas holidays was taken on December 17th, as I recall.
Okay. And so for the next almost month, it was pro forma session?
Correct.
As was the House?
Correct.
Okay. So talk about this litigation risk. I mean, the amount of uncertainty that these actions will create in our economy.
Well, at a time when unemployment is at around 9%, and at a time when one of the things that's chilling our economy and chilling the creation and growth of jobs is uncertainty, and at a time when Americans and American businesses face regulatory compliance costs at an astounding rate of about $1.75 trillion a year, almost equal to the collective tax burden of the American people. The one thing that we don't need is more uncertainty in our regulatory structure. The fact that American businesses may become subject to an order issued by the Nlrb or the CFPB at any time that may or may not be valid, that could be suspect in terms of their validity and therefore subject to litigation that would be costly and would prolong the uncertainty associated with their orders, but litigation that would become absolutely necessary because in many instances it might be a make or break moment for the company. This is exactly the kind of thing that will make our already dismal unemployment problem substantially worse. And so this has real ramifications. This is not a hypothetical injury. This is not an abstract problem. This is a problem that affects real Americans who are just struggling to get by, struggling to find jobs, struggling to find full employment and good compensation. Well, and this compounds that problem manyfold.
Thank you, Senator Lee, and thank you for your testimony. I also want to, just to mark this down as a member of the House, you know, we always have a bit of, we chafe a bit at the actions of the Senate or the inactions of the Senate. But that's not a new thing, nor is that a partisan thing. It's as old as the Republic itself. The Senate is designed to be inefficient, and by God, it lives up to that expectation. And so with that, I recognize Mr. Clay from Missouri, the gentleman from Missouri, for 5 minutes.
Thank you, Mr. Chairman. I really have no questions for the Senator. Thank you for coming today. But let me say that I do have an observation about the process known as recess appointments. Let me say thank God for recess appointments, that we were able to appoint Richard Cordray as the leader of the CFPB because it is the law. Dodd-Frank is the law of the land, and it's necessary that we observe the law. We are a country of laws, and think about, you know, the function of the CFPB is to protect American consumers, and to have to succumb to the will of a minority of senators who don't want to see this law implemented. The American people know what you're doing, and pretty much this president has pulled the wool off of what you're trying to do. We know you're trying to thwart any achievement by this administration for political purposes, and so let me again restate: thank God for recess appointments, and also for the Nlrb, so that they can be up and running and functioning as a full body to protect the workers in this country. So, Mr. Chairman, I have no question, and I yield back the balance of my time, and it doesn't require a response.
Mr. Chairman, if I could respond to that.
It doesn't require a response, Mr. Chairman.
Yeah. Oh, well, I certainly appreciate it. I think the witness has an opportunity to answer.
Thank you, Mr. Chairman. I appreciate the fact that we have laws, and I need to point out that from time to time Congress will pass a law and then not fund the office in charge of enforcing that law. It actually happens with some regularity. It's happened when Republican Congresses have enacted one law and subsequent Democratic Congresses have refused to fund it. The fact that a law is created but not funded, or the subject of full appropriations by a subsequent Congress, is not lawless. It's part of the democratic institution. And to give you an example, in your home state of Missouri, Congressman Clay, it is urban legend, at least, that it was once legal to shoot a Mormon in Missouri. I don't know whether that was in fact embodied in a statute. It might just reflect the extermination order issued by Governor Lilburn Boggs, indicating that all Mormons, members of my faith, could be exterminated. I'm grateful that that wasn't funded, that that wasn't executed. Now, this is a very different kind of law than that one. But the fact that something is put into law one day doesn't eternally, automatically, inexorably obligate subsequent legislative bodies to fund activities occurring pursuant to that very law. And that's exactly what it means to be in a constitutional republic. We elect people. Those people pass laws and then make decisions about how government is to be funded.
But my colleague wishes to respond. He still has. Okay. I certainly appreciate it. And I would say to my colleague, if the Chair may say, I will enjoy reciting your quote today when we have a Republican president. and perhaps that will happen, who knows, but I certainly appreciate my colleagues' indulgence there. With that, Mr. Lankford is recognized for 5 minutes.
Thank you, Mr. Chairman. Senator, thanks for being here. And I can understand how the President could be frustrated with the Senate. You as a member of that body, I'm sure you have even more frustration with the Senate than we do even on the House, if that's even possible.
It is.
After 1,000 days of waiting on a budget to come out of the Senate, we're all frustrated with the Senate and trying to figure out what's going to happen there. The question resolves around, do the ends justify the means, though? Can we say CFPB is going to do a good thing, so though I know it's not appropriately and constitutionally legal, we'll get something good at the end, so the ends will justify the means? Can we do that in a constitutional republic?
No, we can't. The Constitution is all about the means. That's the whole reason for having a Constitution. It determines the means by which we act. No ends can justify a willful disregard for the restrictions of the Constitution.
Well, let me ask you a follow-up question then. Who gets to define what a recess is or what adjournment is? Does the executive branch define for the legislative branch what's an adjournment and what's a recess, or does the legislative branch define what's an adjournment and what's a recess? Who gets to pick that?
The Senate gets to decide when it's in recess. That is true.
So the President can step in and say, I now declare you in recess?
That is correct.
Okay.
He doesn't control our part of the government, much as he might wish would be true, much as probably every President might have wished would be true.
So in 2007, when Senator Harry Reid kept the Senate in pro forma session to prevent the Bush administration from appointing people in a recess appointment, and the Bush administration acknowledged that by not appointing people, saying the Senate has defined they're not in recess, so they're not in recess. When this administration says, no, I don't accept the Senate's definition of recess, we're going to redefine recess, what precedent does that set?
Well, it sets a new precedent, one that I fear could easily turn into a one-way ratchet, in which subsequent presidents of both political parties, will be unwilling to retreat from that new high watermark established as a presidential prerogative.
Right.
That's what concerns me here.
That's what concerns me as well. The President has also said that they didn't have communication from the Senate, and so it's a recess. So basically, if the Senate didn't talk to me and send me messages, did any bills pass between the 17th of December and the 22nd of January? Was there any communication between the Senate and the President?
Yes, there was. And in fact, there was a very significant piece of legislation passed, one that the President urged the Congress to pass on December 23, 2011, that dealt with the payroll tax holiday extension.
Correct. So the President's statement that there's no communication happening is not accurate. There was communication happening. These pre-forma sessions did allow for communication. In fact, did allow for business. So the statement was made, this is not for business purposes. Obviously, the payroll tax extension did pass during that time. That seems like business to me.
That assertion is neither factually accurate nor correct as a matter of constitutional law.
Did the Senate ever have hearings on the candidates for NLRB, all three of them?
No, it did not. And as to two of them, there was no time where they could have even possibly convened such a hearing.
So the advice and consent, not only was there not even a release of the names, there wasn't even the possibility of a hearing. So to say this is a recess appointment, you have no possibility for hearing. So this wasn't just a matter of I submitted them earlier, you hadn't acted on them. This was a matter of, oh, while you're out of town, I'm going to just put two people into office for the next 2 years.
That's correct.
Okay. I have a letter from the Associated Builders and Contractors, which I'd like to enter into the record if that's possible, Mr. Chairman. Let me read one statement here. Not only from, this is from the Association of Builders and Contractors, not only will this radical NLRB anti-worker and anti-business actions further damage prospects of investment and job growth, but questions about the NLRB's authority to act will invite litigation and ambiguity at a time when we need it the least. I'd like to ask unanimous consent that this letter be entered into the record.
Without objection.
I have serious issues, which I can hear from you as well, because of the precedent that this sets. It sets a precedent that a president at some future date can reach into the Senate and define when they're on recess and when they're not, and who he can appoint and who he cannot, and extend them in a January time period to try to get 2 years. With this precedent, if it stands, I don't see anything in the way from some future Memorial Day weekend, the President saying, the Senate's not communicating with me over this long weekend. I'm going to fill every court vacancy across the country, and they'll be there for the next 2 years, and you can't stop me. Do you see anything in this that would stop that?
Logically, it would be a very short hop indeed from the OLC memorandum justifying or purporting to justify these recess appointments and the kinds of recess appointments that you describe occurring over a weekend.
Okay. With that, I'd yield back.
Yes,
I would, absolutely would yield.
Just one quick question. Mr. Connolly sort of berated and told you of his disapproval. Who would have or could have, not the 44 or the 47, who could have in fact held hearings, particularly let's talk about the NLRB. Who schedules those?
The committee.
And the committee is controlled by?
Democrats.
And did they schedule a hearing on NLRB appointees?
At least not with respect to the two that were nominated on December 15th.
And who could have scheduled the vote on the first one?
Democrats in the Senate.
And it wasn't the 44 that stopped that, was it?
Correct.
Thank you. I yield back.
Gentleman's time has expired. And no one on their side. Okay. Yield myself 5 minutes for the purpose of question. Senator Lee, I certainly appreciate your being here with us and your leadership on this important issue. My colleague from Oklahoma concluded with the main focus of my questioning in that the precedent here is pretty dramatic if we do not undo what has occurred. And it's my understanding the Department of Justice memorandum that in essence said that the President has a unilateral authority or ability to decide when you, the Senate, are in or isn't, is unprecedented in this sense. Is that your understanding as well?
Yes. I'm aware of no precedent anywhere, and there was none cited in either in the OLC memorandum or in any other source that I'm aware of identifying any other presidential recess appointment occurring under this set of circumstances.
And I think in your testimony you emphasize that this isn't about partisan politics. This is about the institution of the Senate and probably most importantly the checks and balances that our Founding Fathers so wisely included in the Constitution in protecting the American people from, in essence, tyrannical rule. And that be understood here, because today, obviously, the partisan nature of Washington and the media's focus on that can maybe shift the focus here from this is truly about the Constitution being upheld. And if we're not diligent in ensuring, in this case, the Constitution is upheld, we set a precedent, as the gentleman from Oklahoma said, that why, just in this instance, why isn't, hey, you adjourned on a Thursday with the plan on coming back Monday, and the President, whomever would be in that office in the future, say, hey, you're out of session, you're recessed for the weekend, I can appoint whomever I choose. That would eliminate the checks and balances and the advise and consent rule.
Yeah, that's exactly right. And this is what the Founding Fathers had in mind when they decided, they considered but decided against giving the President the unilateral authority to appoint nominees without Senate confirmation because, quote, the people will think we are leaning too much towards monarchy, close quote. We were getting away from a system of monarchy in Great Britain. We didn't want one here, and that's why we did this. You're absolutely right in suggesting that this is a slippery slope and that in the future, regardless of whether it's a Republican or a Democrat in office, this could become a problem, and it's a problem that could lead to the rendering a nullity or a virtual nullity, the Senate's confirmation prerogative.
Well, and I think well, I certainly respect my colleague from Missouri's statements about his opinion that the Senate's politically motivated, the minority members, Republican members, in blocking. Even if that was the case, although I think that the fact that there was not even a hearing held on the two nominees with NLRB appointees, that even if it was the case, that would be the prerogative of a senator, and ultimately the public would decide whether that's a responsible approach or not. But it's still the constitutional right and prerogative of a senator to block a nominee for whatever reason they choose, and ultimately the voters will decide whether they were responsible in the conduct they engaged in. But it's not the President's prerogative to say, well, I'm going to usurp that authority and unilaterally just do what I believe, what I want to do. So, Senator Lee, I again want to thank you for your leadership on the issue and your constitutional expertise and knowledge that's so important to this debate, and the focus that this is not about partisan politics. This is about the Constitution being upheld and not allowing a dramatic, wrongful precedent to be set that could have lasting implications for the checks and balances of our governing process here in America. So with that, I'll yield to the gentleman from Michigan, Mr. Walberg, for the purpose of the question.
Thank you, Mr. Chairman, and thank you, Senator Lee, for being here. We appreciate your service, and we appreciate you being outspoken on constitutional issues of importance. With no ill intent towards you and your service, because, as I've said, I appreciate your activity. But it's been said much by those of us members of the People's House how frustrated we are with a do-nothing Senate, a literal do-nothing Senate. 1,007 days without passing a budget, without dealing with over 30 bills that we've sent for jobs purposes, and then listening to some of the cynical pandering by some of my colleagues on the other side of the aisle saying that we're not doing anything with jobs. It's frustrating. When I go back to my district and I hear the frustration of my people, who are frustrated not simply with Democrats but with Republicans, with us all, that things aren't getting done. It is challenging to take that knowing that we're attempting to do it. So I can certainly surmise how the President might feel when he sees his Senate not providing affirmation to his appointments, confirming them, and letting him go on with what his purpose is, what his intended process is about, and what his objectives are. I can understand that. But here in the People's House, we understand more maybe than any other branch what that means, that we are given the pleasure, privilege, honor, and duty of representing the people according to something more than just whims and wishes. And I'd love to say to the people back in my district at certain times when I'm not thinking clearly, well, we will just go on and do it ourselves. But the Constitution doesn't allow that. You made that very clear. Senator Lee, could you explain to us as clearly as possible why there is an important process called confirmation that only the Senate is given to do, and what important outcomes that has for the people of this great country under a Constitution that's been established for them?
Executive branch officials, particularly in this day and age, and including and in particular these nominees, hold positions that wield enormous authority. Law enforcement authority, and in some instances, somewhat regrettably, in my opinion, wholesale policy-making authority that can almost be likened to the authority that we wield as legislators. But regardless of how you feel about the underlying statutes that give enormous policy-making authority to executive branch officials, they wield tremendous authority, as do the Federal judges, who also have to go through the confirmation process. And so the Founding Fathers felt that it was absolutely imperative that these nominees receive in all instances where the Senate was not in recess for purposes of the Recess Appointments Clause, the rubber stamp of at least one House of Congress, and for whatever reason they chose to give that to the Senate. And because they did, we take seriously our role to make sure that the President's nominees get vetted, to make sure that any who do not have the support of those voting in the Senate don't get confirmed and don't move on. I think the best way I can summarize my answer to your question is just to say it's important because it's what the Constitution requires. We have to follow the Constitution, even where it's frustrating, even where it doesn't make sense to us, even where it might thwart the objectives of our President. We have to follow them, and when we don't follow them, we set a dangerous precedent. Because if we're willing to ignore them for one purpose or another, for the political convenience of the President or someone else, then we ourselves remain vulnerable in every other area. We rely on the Constitution to protect our free exercise of religion, our free speech, and everything else, every other one of the rights that can be found in that Constitution. We have to honor its procedures as well, or else they won't be there for us when we need them, because we always need them.
We always need them. And the Senate, unlike the House, at least originally intended, and I know it's been amended with the 17th Amendment, but represented the states, a broad concern, not just individual people in concern, but a broad concern for the whole future of this great country as undivided states and peoples together. When I hear the President in the State of the Union address talk about we need to get this done, and if you won't do it, I'm going to do it, That's a concern. And I think it's being acted out and expressed in this process here of non-recess, recess appointments, stepping down on the Constitution, committing a constitutional crisis, and denigrating the body that is responsible for confirmation, oversight, care for what this country needs, and making sure that we don't have a monarch. So I know my time has expired, but I certainly appreciate your commitment to the Constitution and affirmation today of its primacy. Thank you.
Seeing no additional questions, I'll thank the Senator with one closing question, well, comment. Wait a second. Well, we will have one more. But before we do that, just quickly, I suspect that the reason that the Founding Fathers gave you the requirement for advice and consent is they intended you to do a lot less than you're doing with the people's work in the House. And I might just mention that they didn't expect you to screw around with appropriations quite the way that you did. But having said that, I just wanted to ask you one quick question. If we wanted, as the President wants, up or down vote on every one of his appointments, and he wants them in a timely fashion, would it be equally fair for you to consider every vote of the House that we send over that dies in the Senate, and for us to consider every Senate bill, forced to consider every Senate bill in its form that comes over from the Senate? Isn't it sort of that entire bucket of it is the way it is, not the way we'd like it to be?
Yes. The fact is, governments are made up of individuals, especially in a representative government like ours. Individuals have opinions, and those opinions, in the case of elected officials, are based most frequently on the opinions of those they represent. We do have a country in which people disagree. We're not always going to have agreement. Yeah, it is true, I suppose, if you take the same logic that would go into saying, let's have a rule change with regard to prompt automatic consideration of all nominees. The same logic might suggest prompt automatic vote and consideration by the House of all Senate legislation and vice versa.
I thank you. And we now will get to our final questioner, if you have the time to give us 5 more minutes. Thank you, Senator. We now recognize the gentleman from Arizona, Dr. Gosar.
Senator Lee, thank you so very much. This just brings point of reference that this isn't the only thing that you may have seen as a violation of our Constitution, because it seems that we feign these rules when we want them, and then we disdain them when we choose to avoid them. Are there any other things that you have seen this administration do besides these appointments that have bothered you in regards to the Constitution, violation of the Constitution, rules and regulations?
I've had a number of disagreements with this administration, both on matters of policy and on matters of constitutional interpretation. Let me just focus on 2 or 3. One dealt with the President's decision to engage the United States in something that I consider a war in Libya without a declaration of war from Congress. That is a congressional prerogative outlined in Article 1, Section 8, and not only did he not get a declaration from Congress, but he didn't even consult Congress. He sort of advised a few leaders in Congress as the jets were on their way to undertake that action, but he never got a declaration of war. I wasn't real pleased with that. Nor was I pleased with the President's decision to sign legislation that I read as undermining the 4th, 5th, and 6th Amendment rights of individual Americans that can be read as I read it, to give the executive branch the power to detain indefinitely even U.S. citizens without trial, without a formal grand jury indictment, without the right to counsel or trial before a grand jury based on an allegation that they've become enemy combatants. He signed that while protesting it, but I disagreed with his decision to sign it. I certainly disagreed with the policy and the constitutional analysis that went into the passage and signing by the President of the Affordable Care Act, and I disagree with the constitutional analysis outlined in this 23-page memorandum written by the Office of Legal Counsel. Very good lawyers, some of the very best I know, and they did the best job that they could, but they came to a conclusion that is wrong.
So, Senator, so if we exert, trump the Constitution, the checks and balances are relatively slow, are they not?
Yes.
So you have the monarchy looking at the ability to enforce or push something forward without having a means to correct it very quickly.
Yes. Yes, that's right. And the fact that it's slow is by design. That's how we prevent the undue accretion of power to a chief executive, which the Founding Fathers knew presented some danger to individual liberty in America. And that's why we split up the power of the chief executive. Now, it's interesting. Every time our Federal Government has expanded, and every time the authority of the executive has expanded at the expense of the Congress, and every time Federal authority has expanded at the expense of the States, you've always had one common ingredient, a president, presidents like Woodrow Wilson, especially Woodrow Wilson during and in the lead-up and the aftermath of World War I, who have said, look, these are desperate times, and I've got to be able to act, and I can't be slowed down by this elected body who doesn't want to do my will as quickly as I want it to do. If you look back to that era, you'll see that a lot of individual liberties were violated, and you'll see that the government expanded at the Federal level at the expense of the States. You'll see that the President's authority often expanded at the expense of Congress. We need to not make those kinds of mistakes again and again and again. This is the kind of thing that, if left unchecked, will easily turn into another one of those mistakes.
And, you know, I caution my colleagues on the other side of the aisle of upholding rules. I hope they remember that tomorrow, you know, when we have a special guest. I'd like to yield the balance of my time to Mr. Gowdy, if you would sure like it.
I thank the gentleman from Arizona. I want to thank you, Senator, for how generous you have been with your time this morning. Two things, and I'll shut up and let you take the remainder of the time. Assume that these appointments are held to be void ab initio 12 months from now, 18 months from now. What's the practical impact of having a year and a half's worth of litigation that's then undone? And if you would please consider, along with your colleagues, like-minded or otherwise in the Senate, seeing if you do have standing to stand up for the constitutional process.
Great. Thank you, Congressman Gowdy. The first impact, I think, will be that the parties will have undertaken a significant effort in litigating the validity of orders issued by the Nlrb and the CFPB. Hopefully no one company will have to litigate orders issued by both entities, but I suppose anything is possible. In addition to the expense and the delay related to litigation, these companies and other companies, even those who may not be litigating, even those who may just be anticipating an order but might not receive it during that time period, will inevitably have had to avoid making the kinds of investments that we desperately need in order to create jobs. It's almost impossible to measure, to quantify in any precise sense the amount of economic loss that will come from this. But one thing of which I can be sure is that loss will come, and it will be significant. And so this is yet another reason why we shouldn't be doing this. Sometimes my wife tells our children, just because you can do something doesn't mean that you should. Now, perhaps the President can do this and get away with it, at least for the time being, as a matter of raw political power and will. But the fact that he can do that doesn't mean that it will, in the long run, survive constitutional review, as I don't believe it will. And more importantly, it doesn't mean that he should. There are established procedures that go along with the recess appointment power. It is in the Constitution. It's there. But he needs to follow the practice, the procedure that makes sure that it doesn't swallow the rule. You can't let this exception swallow the rule. And that's the risk here. He's doing this not just at the expense of individual senators. That's not the important thing. He's doing this at the expense of the people who are living in an economy that's depressed, where job creation is low, in part because of actions like this that create so much uncertainty in the marketplace. You have my assurance that I and my Republican colleagues will continue to explore and attempt to exhaust every available option, including any that may be available in court. I've been advised by some legal experts that it is very unlikely that we individually would be able to establish standing. But we know that it's inevitable, and it's true that those subject to the rules will have standing, and at a minimum will be able to participate as amici curiae in those actions. And so we would like to do that.
The gentleman's time has expired. And seeing no one else seeking recognition, Senator, what you have done for us is especially appreciated. It is not often that members of the House or of the Senate give so much time to answer full questions in their area of expertise. So please have our gratitude and tell your friends they're always welcome. And with that, we'll take about an 8 to 10 minute recess while they set up the next panel.